Welcome and thank you for joining part 2 of Seyfarth's webinar micro-series to kick off the release of our 2023 California Peculiarities publication. This session will cover California leave of absence, sick leave, and vacation pay. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your questions are not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Anne-Marie.
Thank you very much, Brenda, and good morning, good afternoon, depending upon your time zone. My name is Anne-Marie Zalatel, and I am a partner in Seyfarth's Century City and New York offices. I'm joined by my colleagues, Kathy Feldman and Juan Real Garcia, who are based in Century City and downtown Los Angeles, respectively. And we are happy to be here today with you for this micro webinar. We have a lot to cover in 30 minutes, so we are just going to jump right in. Next slide, please. So these are the topics that we are going to touch on today, and I am going to kick it off with California Family Rights Act and California Paid Family Leave developments. Next slide, please. So as I'm sure most, if not all of you know, California for years has had its own FMLA law, the California Family Rights Act, which is widely known as the CFRA. And for years, the CFRA essentially mirrored the FMLA and the leaves, FMLA leave and CFRA leave for the most part ran concurrently. There was a big exception for pregnancy disability leave, but for the most part, they ran concurrently and had the same eligibility requirements, the same length of leave, the same reasons for leave. But over the past several years, the CFRA has greatly expanded and almost no longer resembles the FMLA. And it has expanded in several important ways. First, employers with at least 5 employees anywhere are now covered. A common misunderstanding is that the 5 employees need to be in California. They can be anywhere as long as you have 1 employee in California. For years, like the FMLA, the CFRA required that the employer have at least 50 employees. So now small employers are covered under the CFRA, even if they aren't covered under the FMLA. Also, the family members for which an employee is permitted to take time off to care for a family member with a serious health condition, those family members have expanded under the CFRA. They now include siblings, grandparents, grandchildren, even parents-in-law, and as of January 1st of this year, a designated person. Next slide, please. So designated person, the definition under the CFRA is any individual related by blood or whose association with the person is equivalent of a family relationship. So there doesn't have to be an actual family relationship. So it's just the equivalent of a family relationship, which is a really subjective standard. And so it is difficult to push back on an employee who says that they need time off to care for a designated person. The employee must be allowed to designate that person at the time he or she requests the leave. Notably, employers are able to limit an employee to 1 designation or 1 designated person in a 12-month period. So it's not like, the employee has 12 weeks of leave in a 12-month period. They can say in this week they're taking time off to care for their good friend, and next week it's a different friend, and so forth. You can limit the designation to once in a 12-month period. Importantly, there's no longer a geographical proximity requirement. So under the FMLA, and until a couple of years ago under the SIFRA, to be eligible, the employee had to work at a work site with at least 50 employees within a 75-mile radius of that work site. And that requirement has been completely stripped from the SIFRA. So that is no longer an eligibility requirement. Next slide, please. Also, these various ways in which the SIFRA has been expanded have significant implications for you. First, it's going to be much more frequent where you'll have a situation where employees who are not eligible for FMLA leave, for example, because they don't work at a work site with at least 50 employees within a 75-mile radius, may still be eligible for 12 weeks of SIFRA leave. Also, a California employee who takes up to 12 weeks of SIFRA leave to care for a sibling, or for that matter, any other reason that is not covered under the FMLA, that employee still has an additional 12 weeks of FMLA in the same 12-month period for an FMLA qualifying reason. So therefore, up to 24 weeks of FMLA and 12 weeks of FMLA and 12 weeks of SIFRA leave, so a total of 24 weeks. Of course, the employee has to satisfy the FMLA eligibility requirements. Also, there's a handbook implication. So SIFRA has a mandatory written policy requirement. You should ensure that your SIFRA policy has been updated to remove the geographic proximity requirement and to add the additional family members, including the designation or the designated person. You also want to really be sure to include that employees are only able to designate one person in a 12-month period. It's really critical that that be in your policy if you intend to enforce that requirement. Next slide. So just want to flag for your attention, as of January 1st of this year, the maximum weekly California paid family leave wage replacement benefit has increased from $1,540 to $1,620. Also, the applicable deductions from employee wages for the paid family leave and California state disability insurance benefits was actually reduced to 0.9% of the first $153,164 earned in a calendar year. So the maximum withholding per year is $1,378.48. Also, the paid family leave pamphlet was updated, and you want to make sure that you are using the current pamphlet. And with that, I am going to turn it over to Juan to cover California paid sick leave developments. Juan?
Thank you, Anne-Marie. And thanks to everyone watching for being here. I'll be going over updates to the paid sick leave law in California. And specifically, I'll be talking about one major update that recently came into being. So as you know, in California, most employees are entitled to a minimum amount of paid sick leave for purposes of preventative care or diagnostic care and treatment of a health condition. Up until this year, an employee was entitled to take paid sick leave for themselves and for a narrowly defined category of family members. The former definition included an employee's children, spouse, grandparents, siblings. With the enactment of AB 1041 last fall, amended California's paid sick leave to include designated persons, just like with SIFRA. The amendment became effective on January 1st of this year. Unlike with the SIFRA designated persons standard, The definition of designated persons for sick leave purposes can be anyone designated by the employee at the time that they request to take paid sick leave. So this is pretty broad. There's no requirement that the employee and their designated person be related by blood or an equivalent family relationship, nor that they belong to the same household. The designated person can be anyone, technically. An employer may not ask their employee to make the designation ahead of time. The employee is entitled to designate the person at the time that they request leave. But the employer may limit designated persons to just one in a 12-month period. The inclusion of designated persons into the paid sick leave law also implicates the Labor Code's KinCare law, which references paid sick leave. KinCare authorizes employees to use up to half of the sick leave they have accrued annually to take care of a sick family member. And that law instructs that family members to have the same meaning as it does under the paid sick leave law. So under KinCare, an employee's designated person is also covered. So what does this mean for all of you? Employers should update their policies to reflect that an employee is entitled to take paid sick leave for a designated person, and that the employee may designate that person at the time that they request to take leave. The policy should emphasize that employees are limited to just one person in a 12-month period. And employers should also consider devising a way to keep track of that designated person, to establish a written record should an employee ever claim that they've not been given the opportunity to designate a person for paid sick leave. So that's the major change to paid sick leave, and I'll hand it off to Kathy next to discuss bereavement leave updates.
Thank you, Juan. Good morning, everyone. So in California, effective January 1st of this year, the bereavement leave law has been amended to require up to 5 days of bereavement leave for any employees that have been working at least 30 days in the last 12 months. And this applies to most employers as long as you have a minimum of 5 employees. The bereavement leave can be taken consecutively or not, as long as the leave is completed within 3 months of the date of the death of the family member. But employees can parse that out however they choose. And this law prohibits an employer from denying a request for that leave. So employees have broad discretion to take that leave as needed in that 3-month window. You've heard a lot already about who different leaves apply to, and if it's family member or a designated person. Under bereavement law, they don't specifically refer to designated person. So arguably, it's extended only to family members such as a spouse, a child, parent, sibling, etc. But the law does refer to Government Code Section 12945.2, which was the section that was expanded to include the designated person. So there is a question as to whether a person could take bereavement leave for a designated person, although strictly that's not what the law provides for. Employers can request some documentation confirming that there is a need for the bereavement leave, and that's a pretty broad right. You can ask for a death certificate, an obituary, written verification of the death, or other types of documentation along those lines. The important thing to note about this new law is that if you don't already have an existing paid bereavement leave policy, then the employer can provide the bereavement leave as an unpaid leave. But employees are also allowed to use vacation time, personal leave, accrued and available sick leave, other compensatory time off that they might otherwise have available as well. So again, there's a lot of flexibility depending on what your existing policy already provides for. And there is a pretty narrow carve out for collective bargaining agreements. You can only be exempted if the CBA specifically provides a bereavement leave policy that is at least as generous as this new law. In other words, it has to provide for at least 5 non-consecutive days off within 3 months in order to qualify for the exemption. And with that, I'm going to pass it back over to Anne Marie.
Thank you very much, Kathy. So there was a very important decision, or potentially important decision, even though it's an unpublished decision, that we want to bring to your attention from the decision. It's a Ninth Circuit decision that was issued earlier this year in March. It's the Cinnamon Mills versus Target case. And for decades, the labor code in California has provided that an employee must be paid out for all accrued unused vacation upon employment separation, regardless of the reason for separation, at the employee's final rate. And so this decision addressed the definition of final rate and what does final rate include and how is it calculated. And quite frankly, everyone had assumed until this decision was issued that the point of this provision was simply that an employee had to be paid out at his or her final base salary or final hourly rate. You couldn't, for example, if an employee was earning $20 an hour, a non-exempt employee, say, oh, well, we're going to pay out your vacation at the minimum wage. But, you know, this decision held something a little bit differently. In the case, Cinnamon Mills worked at Target and she earned a base hourly rate of $15.50 an hour at the time. She also earned on each shift that she worked virtually an hour, $1 per hour shift differential. And so in this particular case, the Ninth Circuit held that her final rate, and Target paid out her accrued unused vacation upon separation at her base, her final base hourly rate of $15.50 per hour. And the Ninth Circuit held that her final rate was not just her base hourly rate, but rather her base hourly rate plus her shift differential. So this decision, you know, it leaves many questions unanswered. You know, what, for example, what besides shift differentials need to be included in the final rate? Also, in the Cinnamon Mills case, Ms. Mills earned a shift differential virtually every day. Is the result the same, though, if an employee typically does not earn a shift differential and did not earn a shift differential their final week of employment, but, you know, only earns that shift differential when on rare occasions they work on a holiday or work a night shift? Does the shift differential still have to be included? Also, what about other forms of pay that non-exempt employees often receive, like bonuses or commissions? So a lot of these questions are yet to be answered, and we predict that at some point the California Supreme Court, or at least the California Court of Appeal, is going to need to weigh in on the issue. Also, one additional question is whether waiting time penalties will be owed now that the Cinnamon Mills decision has been issued, if, you know, the employer does not include a shift differential in the final rate. So at this point, we are advising clients to, if you have employees at least who work in the same circumstances as Ms. Mills and regularly earn that shift differential, that you include that shift differential in the final wage rate, and that if you do not, you potentially are subject to waiting time penalties for failure to do so. And so with that, I am going to turn it back over to Kathy.
Hi again. So before I jump into our last topic, which is going to be local leave law development, so I'm just going to read out the CLE code for everyone, and that is SS, as in Seyfarth Shaw, 3674. SS 3674. Next slide, please. All right, so there have been in California local leave laws on the books for years and years, and specific jurisdictions tend to be prime suspects for developing more and more local leave laws. But we see these a lot in San Francisco, in Berkeley, Long Beach, Los Angeles, all the kind of LA area, Santa Monica, West Hollywood, San Diego, all those types of jurisdictions. Many of them have not had a lot of changes over the years, but some jurisdictions we've seen a lot more activity lately. First and foremost, West Hollywood, very recently in May of this year, released updated regulations to their paid time off ordinance. And we're actually going to be publishing a blog post on this shortly, so you will get some of this information in two forms. But the key changes that they made in West Hollywood were that they are now providing all employees, part-time and temporary employees as well, who work at least 30 days within the year for the same employer, with at least 24 hours of compensated leave for sick leave purposes. That has to be available for use beginning on the 90th day of employment, 90th calendar day of employment. So that change really just brings West Hollywood in alignment with California's state paid sick leave requirements. So it shouldn't be too big of a lift or burden for employers that are operating within West Hollywood or have employees that are working remotely from West Hollywood. That 24-hour allotment is also part of West Hollywood's total allotment that they require of compensated leave off per year, which, as a reminder, is 96 hours for full-time employees and a pro rata amount of that for part-time employees. They've also made some changes to that delta of time between the 96 and the 24. So they've changed the accrual rate for compensated leave that's classified as paid sick leave beyond the 24 hours. It was previously a 0.047 accrual rate, and it's now a 0.033 accrual rate, which essentially equates to 1 hour of paid sick leave for every 30 hours worked. And that change, again, is probably mainly due to the fact that they're now setting aside this 24 hours for sick leave that was not previously designated that way. They're also reducing the waiting period for both the compensated and compensated time off. So under the new regulations, West Hollywood employees are eligible to use uncompensated leave and any accrued compensated leave after the first 90 days of employment. This is a lot shorter. The old regulations previously provided for a 6-month waiting period. So those are the key changes that we're seeing in West Hollywood. San Francisco is another one of our frequent flyers that likes to have new and different leave policies all the time. In late 2022, they passed an ordinance, the Public Health Emergency Leave Ordinance. And this essentially was in response to the COVID pandemic and kept on the books a permanent ordinance now. Anytime there's any type of public health emergency, it has to be a declared public health emergency, that there's this bucket of leave that employees can use. And they had kind of set allotments for the tail end of 2022 and then new allotments for 2023 and moving forward. The important thing about this bucket of leave, and something that we've advised employers on a lot, is that even though there might not be an ongoing declared public health emergency, employees always need to have an allotment of PHEL available to them. So, basically, they've got that leave. They can't use it unless there's a qualifying emergency, but they need to make sure, you need to make sure that it's available to them. And in terms of qualifying events, like I was saying, it needs to be a declared public health emergency. Those are going to be posted. San Francisco has a specific website where they post any such emergencies, but also what qualifies is fare the air alerts, any type of air quality emergency, which is not published in the same place, but San Francisco employers can sign up to get alerts for when there's any type of compromised air quality. And employees that are eligible to take leave under PHEL for Spare the Air specifically is limited to a very specific vulnerable population who's working primarily outdoors. So that's not going to be something that applies to all employees, even if there is an alert in place. Once there is an emergency or some type of qualifying event that allows employees to take PHEL, any employee is eligible to take that category of leave regardless of their duration of leave, whether they're part-time, full-time, temporary, seasonal. And so we're seeing a lot of questions really just about what kind of allotment there needs to be, even though there isn't something currently ongoing right now. Although we are seeing COVID spikes, so who knows where we will be in the coming months. San Francisco also recently created a leave category that's a little outside the scope of what we're talking about today, but I'll touch on super briefly. It's a pay differential for military leave, and that became effective in February of this year. They're the first jurisdiction in the country that now requires private employers to provide a differential pay to employees that are called to active military duty. And it applies to any employer with at least 100 employees nationwide, not limited to San Francisco. And essentially, it provides 30 days per year of differential pay to bridge the gap between an employee's military pay and what they would have otherwise earned from a civilian employer. So we'll see if we start seeing more leaves of that type of nature in other jurisdictions. And finally, just as a reminder to anyone that's got employees in Oakland, Oakland is the only California jurisdiction that still has a COVID-19 paid sick leave mandate. We are checking constantly to see if they've taken it off the books, and it hasn't happened yet. So just to keep in mind that that's still something that for Oakland employees is ongoing. And that's the totality of kind of the local leave developments that we've seen of late, and brings our presentation today to a close.
Thank you so much, everyone, for attending today. We appreciate your time. We know you're all super busy, and we hope you found the information helpful. And please don't hesitate to reach out if you have questions.